stories?
Yeah.
Well, there's like over 17 to 50. There's
We ready? We ready? All right. Good morning, everybody. I'm District Attorney Jonathan Blodgett from Essex County, and I'm pleased to have you all here today. I want to first thank President John Keenan for this great space that he allowed us today. President Keenan, thank you very much. John and I have been friends for years. We both have brown hair.
You still have it.
That's pretty funny.
But this is, to my way of thinking, the most important legislative initiative that I've had in 20 years as district attorney. We're talking about something that's so important. We need this legislative fix to protect children, sexual assault survivors, as well as the general public. And I'm grateful that we have legislators here today. I thank you for being here, and we'll have more to say about that later. But we will kick this off because it's important that we hear the voices of survivors, and we'll do that in a second. I did run this by Secretary Reidy, and please indulge me for 1 minute. I want to read 3 cases in Essex County, frankly, that are so important to us, and that my staff has handled with tremendous competency, but it's important the public understand what we're up against and why we need this legislative fix so desperately. 3 quick cases. The first case involved a 43-year-old man who met a 15-year-old female child online. He made multiple attempts to entice her to meet him over the course of a few months. The girl finally agreed, and the defendant picked her up at school and took her to an Amesbury hotel. The defendant previously paid for the room, snuck the child in the side door. He then engaged in unprotected sexual intercourse with the girl. He directed her to shower away any forensic evidence. The defendant was held without bail pursuant to 58A in the district court. The defendant argued rape of a child was not a predicate offense. A judge in Superior Court agreed and the Commonwealth appealed. Because, and this is the SJC ruling, because there was no element of the use, attempted use or threatened use of physical force, rape of a child does not qualify as a predicate offense. You've heard that, similar stories from the governor and lieutenant governor. In a concurring opinion, Justice Lowy, a former justice of the Superior Court, noted that aggravated rape of a child, age difference over 10 years, is deeply offensive and disturbing conduct regardless of whether the force is used. He noted that although the holding is correct under the law, the way it is written is nevertheless unfortunate. He specifically addressed the governor's proposed bill that would resolve this loophole and asked the legislature to consider the omission of this offense in the statute. It needs to be corrected. The second case is ongoing, so I'm going to redact certain identifying information. The defendant is a 49-year-old police officer, communicated with a 13-year-old boy on a dating application called Grindr, I guess. He arranged to meet the boy in order to engage in sexual activity. The defendant agreed and arranged to meet the boy at a local park late in the evening. The boy took his bicycle to meet the defendant and entered his car with a full set of braces. The defendant engaged in sexual activity with the boy. He was charged with rape of a child under the age of 16 and indecent assault and battery on a child under 14. Pursuant to a search warrant, the defendant's home and car were searched. Multiple firearms and hundreds of rounds of ammunition were found, all lawfully owned. However, the AR-15 military-style rifle, which was also lawfully owned, was found unsecured in the defendant's car with hundreds of rounds of ammunition. His car was on a public street here in Essex County where the defendant attended a training. The Commonwealth filed the 58A and the indecent AEB charge, and the SJC had already ruled pursuant to the Barnes case that rape of a child was not a predicate offense. However, many judges, based on the reasoning in this Barnes decision I previously mentioned, that indecent AEB was, again, in fact, not a predicate. The SJC held that we previously declined to adopt the sweeping definition of force that the Commonwealth proposes, and we see no reason to do so here. They determined, again, that it's a decent assault and battery on a child under 14 was not a predicate offense. So we really literally are talking about having to have the knife to a minor child in order to bring up 58A. That is outrageous. It needs to be fixed. The third case, which again is a pending case, the victim strangled and repeatedly was punched by her boyfriend. She flees to the police station where the officer notes her eyes to be swollen. As he is speaking with her, the officer noticed her throat begin to swell and several distinct finger mark bruises appeared on her neck. The defendant makes admissions to the police that he assaulted her. The clerk released the defendant a $500 cash bail and a stay away, no contact, no abuse order. The defendant promptly posted the bail and immediately found the victim at a friend's apartment where he again assaulted her. Refused to allow her to leave for several hours. She's able to finally get away and immediately goes to the police and reports the second assault. She tells the police she is very upset he was released, as she was had to rely on having time to get to a safe place. The police make contact with the defendant, who states he is contacting a lawyer and not turning himself in. He appears in court with an attorney. He was taken into custody. We filed a 58A. During the course of the hearing, when we have not had any success contacting the victim. The defendant's attorney indicates the defendant's friends assisted in getting the victim out of the Commonwealth. If that does not make you outraged, nothing will. These are just 3 examples. The legislation proposed by the governor and his administration would allow for dangerousness to be considered by the clerk and bail commissioners. We have to get this done. We have to protect children, sexual assault survivors, and the public. Please speak up and make your voices heard. Thank you. At this time, it's my great pleasure to introduce the Secretary of Public Safety, Terry Reidy.
Thanks, DA Blodgett, and thanks, President Keenan, for hosting us today. What this legislation boils down to is keeping people safe, keeping survivors safe, keeping witnesses to crime safe, and keeping their families safe, and keeping the general community safe. In my opinion, it boiled down to 3 major focuses of a really comprehensive bill, a bill that has common sense changes to fill gaps in the system. It's being able to add offenses that DA Blodgett just currently outlined that aren't part of the current statute. It's being able to hold somebody who's been determined by a judge to be dangerous and that no conditions of bail can keep the community safe, to keep that individual detained for the pendency of their entire case. And finally, it's looking back at a defendant's record, not just the one case that brings him before the court, but looking back and seeing what offenses that person's been convicted of, not charged with, but been convicted of. Because that's the insight into how dangerous an individual is. What have they been convicted of in the past? And under the current statute, the DA's offices have their hands tied. The key to this legislation is giving the opportunity for the district attorneys across this Commonwealth to evaluate cases when they come before them, to make a determination whether or not to move for a dangerousness hearing. It's not in the DA's power or the police department's power to wave a magic wand and detain them. It has to go in front of a judge. The defendant's due process rights are extremely important. I don't think anybody on this panel is going to say they're not. They have due process rights in court in front of a judge represented by counsel. What this legislation really boils down to are the people you're going to hear from and their nightmare stories of the worst days of their life that you're going to hear from. We've had 4 roundtables: Plymouth, Springfield, Worcester, now here in Salem. And I've mentioned this in the past 3 roundtables after we had Plymouth. And I mentioned this to the governor and to the lieutenant governor. I was a prosecutor for 20 years in Suffolk County and Worcester. I handled horrific cases during my time as a prosecutor. I had many brave witnesses and survivors testify before me in court. And what I told the governor and the lieutenant governor after Plymouth, and it's the same comment and the same observation after each roundtable, is that I've never seen such brave people in my life, in my career as a prosecutor, come forward and highlight the worst days in their life in public to support this bill. So I want to thank you all. I appreciate it. I know the governor and the lieutenant governor appreciate it. And I'm so sorry what you've been put through, but thank you for coming forward. We really appreciate it. And with that, I'd like to introduce Governor Baker.
Thanks, Mr. Secretary, and I'm really more interested in hearing from you than I am in listening to me blather on about one thing or another. I do want to thank John Blodgett for his work on this issue. Some of the decisions he made as a district attorney, knowing that in the end, he would be denied the opportunity to have a hearing in some of these cases, was his way of shining a light on the fact that in Massachusetts, we have a number of laws that have gaping loopholes that really bad people have taken advantage of. And I do want to thank the legislators for being here today to hear these stories. I can't imagine what listening to John tell those stories means to you folks. And the only thing I would add to what Secretary Reidy said is based on the commentary that we heard and the stories that were told at the events that we've had prior to this one, while it is incredibly generous and brave for you to be here today, the simple truth of the matter is your nightmare never ends. You carry it around for the rest of your life. And the fact that we here in Massachusetts are not doing everything we can to limit the impact and the damage that's done by the repeated incidents that many of you have had to deal with is appalling. And I really do hope, and the idea somehow that we're turning criminal justice upside down with this very targeted and specific proposal is insane. And I really do hope between now and the end of the debate in the spring and the summer and July, that your voices, which in my opinion are the only ones that matter in this issue, will be heard, and that there will be an opportunity for you to believe that your decision to come forward and to share your stories the same way folks did in those other roundtables we've had will not have been in vain, and that you will have done something to protect those who come after you, who find themselves in similarly horrific and awful and terrible and ongoing circumstances and situations. So thank you for being with us.
Thank you, Governor. I will be brief as well. Obviously, thank you to the DA and to your whole team at the office and all the work that you do day in and day out, hearing and supporting victims and witnesses in your line of work, and to all your counterparts across the Commonwealth. I so appreciate our legislative colleagues being here today as well. It's really important to have your presence, and most importantly, for you to be here. We did something important a couple of years back with criminal justice reform. There were needed reforms, and we worked through the challenges associated with that. It was important to do. This is equally as important, to reform the laws, to make sure that victims and survivors have a level playing field, and most importantly, to improve the public safety here in the Commonwealth. As we know, there are gaping holes in our laws that create not only public safety challenges and problems, but nightmares for individuals like yourselves, and unfortunately, too many individuals that don't come forward and find themselves day in and day out terrorized by those who abuse them and hurt them. So today, and through the other survivors that came through, we're working with your voices to help tell the reasons why we need to change these laws, and that the proposals that we have made will do that. I wish that you did not have to come forward and relive the circumstances that brought you to the criminal justice system. But we need you, and we appreciate you, and we thank you for your courage and for your support.
Thank you, Lieutenant Governor. We have, as you've already heard, some very brave panelists who will speak this morning for about 3 minutes on their experiences. And they are Kate M., Erin K., Bob D., Carla P., and Tara. We're going to start with Kate M. First. Kate?
Thank you, Governor Baker, Lieutenant Governor Polito, and DA Blodgett for having me here today. I fully support the dangerous legislation sponsored by Governor Baker. This bill is personal to me. It is extremely important for the safety of my family, the community, and the Commonwealth. Chris Prue of Winthrop, over several years, embedded himself into our community. He worked in our school system, our summer camps, coached hockey teams, and provided private hockey lessons, all while befriending and grooming the families and boys of our small town of Marblehead. He eventually moved into our town, continuing to build trust of the families. In February 2018, he was charged with molesting all 3 of my boys and at least 5 others. He was indicted by a grand jury in February 2018. He was found to be dangerous in Salem Superior Court. However, he was released as the court found the DA could not file the dangerous relative to child sex offenses. The safety that they felt while he was held in custody was ripped from them. According to the law, child sexual abuse is not one of the charges considered dangerous. It was hard to fathom how this could be. It was very difficult to inform our brave but traumatized children that under the law, Prue was not considered dangerous. The individual accused of these crimes is a perpetrator and is the perfect representation of a dangerous person as described in the bill. He is accused of molesting over 8 children and has been charged on various counts of indecent assault, including rape in Essex County. He also faced additional charges in Middlesex and in Vermont. These boys were brave enough to come forward and share their truth. Now it is our responsibility to continue to keep them safe and ensure that they feel safe. I have commended these boys on their courage and bravery in coming forward. They have felt safe since his conviction, knowing that they were believed and that the person who stole their innocence is again in jail and can no longer hurt them or any other child. In just the last 2 years, there have been numerous cases of child sexual abuse, and due to the deficits in the law, there have been no way to detain these dangerous child sex offenders without bail, even though they are known to be dangerous and have countless victims. I do hope this bill becomes law, as it will keep others safe and provide the criminal justice system with the tools it needs to keep our communities safe. As Governor Baker said when he introduced this bill in years past, it is a fundamental responsibility of the government to keep our communities safe. Recent tragedies have demonstrated the tremendous damage that can result when a criminal justice system fails to identify and detain dangerous people charged with serious crimes. I know firsthand how much these crimes impact the residents of the Commonwealth. Thank you.
Thank you, Kate. Thank you very much. Next, Erin Kay.
I also want to thank everybody here for having us. I'm here today in support of the 2 bills, an act to protect victims of crimes and the public, and an act relative to the harmful distribution of sexually explicit visual materials. These bills will provide additional tools to hold violent offenders responsible and away from survivors. My son is a survivor of childhood sexual assault and child rape, and I know too well the toll the violent crimes can have on survivors and their families. I support these bills because of the trauma inflicted on my son and my family in recent years by a sexual predator named Christopher Prue from Winthrop, Mass. He insinuated himself into our community and then into our individual lives at a very difficult time. We were deep into our grief after losing my husband of 20 years to suicide. My kids and I were now without our best friend and father, and he immediately targeted us. I was contacted by this predator via Facebook Messenger to offer his condolences and to help us in any way possible. He was known to us originally through after-school sports program at my son's school. He was first We were already a devastated family. He took advantage of our grief and our generosity. And I entrusted him with my son on over 50 unsupervised outings and events. We all did. I just assumed, since he was involved with so many people in our town, that everything was okay. Successful grooming involves manipulation of a child, their parent, and the community, so the abuse can be more easily committed without detection. And the grooming started with me. Predators who groom often do so while keeping guise of being kind, charming, and helpful. They cleverly and strategically manipulate their victims, their families, and the community to hide their deviant intentions and avoid detection. 1 out of 6 boys and 1 out of 5 girls will be sexually abused by their 18th birthday. Many of these predators freely walk our streets because they have not been caught yet. 90% of the children abused by someone they know are abused by someone they know, love, and trust. That is why so little is reported and so few are prosecuted. Somehow the current laws seem to work in their favor. Now, I don't know of anyone that would not agree that child sexual predators of any degree would be a crime we would not want added to the list of offenses now. Rape without force. A child has no idea what they would be resisting from a trusting person, force or no force. I feel confident in saying that if the vote were up to the people of Massachusetts, it would pass the first time through. My son is my hero for telling me that day what happened to him. He saved so many. I'll never forget as long as I live. Children are measured by the amount of hurt they feel. Their measure is the burden of painful confusion in a young boy's heart. When the man he so much wanted and thought to be a father figure was doing things to him he knew were wrong. I support the bill because it would allow the judge in any given case the ability to detain a dangerous individual longer than the current 58A states he or she can until their trial. There's absolutely no research that proves that restrictions such as house arrest, GPS bracelets, and prohibiting offenders from being around kids leads to a decrease in these criminals reoffending. These people stop at nothing to feed their obsession, and any penalty would have zero impact on his compulsive thought pattern. There's no rehabilitation, and this has been proven over and over again. This bill, as it pertains to dangerous child sexual predators, is extremely important to not just us personally, but to all our communities in the Commonwealth as a whole. Nobody wants these types of criminals roaming the streets freely. They are a continued threat to society, and it's imperative we protect our children the best we can. If this bill had been in place while this was happening to us and the case was going on and on and on, there were so many days and nights of worry, no sleep, panic, and depression that we would not have to have endured if we knew that he was never going to have a chance to get out. I fought daily and even testified twice at the State House, begging for the law to be changed so that he couldn't get out. I installed security cameras all over the exterior of my house. I had families stay with us on endless occasions for protection. I received threats from his family that told me I better think long and hard about what I'm doing, and I have no idea with what and who I am dealing with. And that was correct. I had no idea what I was dealing with. And when it came to his deranged childhood sexual predator supporting family, over 93% of convicted sex offenders are arrested again for the same offense. There is no cure. The average pedophile molests over 260 victims in their lifetime. And the repercussions of letting these types out on the streets include, but are not limited to, many things. They carry out their abuse without the slightest twinge of guilt, remorse, shame, and responsibility. I'd like to extend my gratitude to the Governor and Lieutenant Governor and DA Jonathan Blodgett and his team for their tireless efforts and advocacy for children and protecting those victims. I am committed to continued advocacy for these bills as long as it takes, because I believe it will help save so many lives from the torture and life sentence that my son, just an innocent, happy-go-lucky little boy, was given for the rest of his life.
Thank you, Aaron. Thank you very much. We'll now hear from Bob D.
Thank you. Thank you all for having me be here with the other survivors. Those numbers are horrifying that you just read. Anyway, my name is Bob. When I was 11 years old, I was victimized sexually by a stranger. He approached me and my friend and said his poodle dog was lost. He asked if we would help him look for the dog. He said he'd give us each a $10 reward if we found the dog. He took our names and addresses so he could send us the money. We were anxious to help and thought it would be fun. However, horror soon ensued. The man lured us to a wooded area very far away from the state-owned pool in Lawrence. Once in the woods, he made me and my friend undress, and then he raped us one at a time. It was awful watching my friend being raped, and I was terrified knowing I'd be next. I thought about running, but I was afraid the man would kill my friend. He feared the same for me. As the stranger eventually let us go, he told us not to tell anyone. He reminded us that he had our names and addresses. It was a terrifying experience, and I always feared he would come to my house and harm me and my family. This stranger was the infamous child predator Wayne Chapman. He admitted to molesting over 100 kids. He had committed countless child offenses in multiple states and in many counties in Massachusetts. He has been a suspect in the disappearance of 2 boys, one from the very pool I was lured from. While I was relieved when Chapman was found to be a sexually dangerous person post-conviction, I can't help but wonder how many child sexual assaults could have been prevented if this dangerousness bill was already law. It's haunting to think that a child predator can be free to reoffend repeatedly while out on bail. And why? Because the child offenses aren't included in the law, because a prosecutor can't appeal bail, and because a judge can't look at the offender's entire criminal history when considering dangerousness. It makes no sense. We need to do a better job protecting children. The failure to act has never has a good outcome. Thank you.
Thank you very much, Bob. We will now hear from Carla P.
Thank you, Governor Baker, Lieutenant Governor Polito, and DA Blodgett for including me in this event today. I know too well that sexual assault can happen at any time. I was unfortunately raped twice in my life, first by a stranger in Middlesex County, and then 12 years later by an ex-boyfriend in Essex County. I was very lucky to have wonderful prosecutors and advocates on my side, especially in Essex, with ADA Kathy Tutman and victim advocate Cheryl Watson. They were tremendous. The Middlesex County stranger rape was very scary because it happened outside of a hotel. My sense of safety was shattered. My life as I knew it was gone. It had haunted me for years. To my dismay, the judge issued a low bail and the rapist was set free while trial pending. The prosecutor said he had no ability to fight the bail status. I nearly dropped the case out of fear of retribution, but I felt a strong obligation to protect other women, so I pressed on. He was found guilty, but to my horror, he only was given 3 years in jail. It took years of intensive therapy before I started to live a better life. Although uneasy, I finally felt better about dating. I met a man that, unbeknown to me, was a wolf in sheep's clothing. At first, he was kind and fun to be with. Lightheartedness is what I needed after years of pain. However, I had no knowledge of his violent history, his long criminal record, or his many years of drug abuse. I tried to end the relationship when he began to show who he really was. One night, he kidnapped me and held me captive at his home overnight. I was convinced he was going to kill me, and he asked me, "How do I want to die?" He brutally beat me, burnt me with cigarettes, and raped me repeatedly. He was high on drugs, and it was terrifying. He stole my cell phone and called my daughter and threatened to kill her and all of us. It was heartbreaking to know the fear of my daughter experienced. He knew targeting my daughter would be very hurtful to me. I was relieved when he was arrested, but relief turned to utter fear when a judge set low bail and he was released. I was so traumatized by his violence that I did not remember all the details of what happened at first. I had not yet reported everything before the arraignment. I was also fearful of retaliation, so I was slow to disclose of all the abuse. I was dumbfounded that the judge could not consider my abuser's entire criminal past, or that the prosecutor could not appeal the bail or file for dangerousness after arraignment. It made no sense to me. Again, I considered withdrawing from prosecuting multiple times out of fear. After he was indicted in Superior Court, the prosecutor fought hard for a higher bail, and it was increased, but he was still able to pay it, and he was free. The fear of him hurting me or my family again was paralyzing. Even though I again thought about dropping the case, with great support from the prosecutor and the advocate, I held on if it wasn't for them. He was eventually convicted and sentenced to 2 years in prison. 12 years in prison, I'm sorry. I thought I'd finally have some peace. However, when he was in prison, he sued me for libel, defamation, and false arrest. He tried repeatedly to vacate my restraining order and filed many frivolous appeals of his convictions. As the years went on, I suffered terribly from the neck and spinal injuries he inflicted. This surgery scar I bear on my neck is a daily reminder of this man's wrath and violence, and the emotional trauma doesn't heal either. I am glad he's a level 3 sex offender so other women can see who he really is. As victims, we enter the criminal justice system as novices, but we quickly become experts of its failure to protect us. Prosecutors and judges need more options to better protect victims from further harm while cases are pending. The judge needs to see the offender's entire record to best inform their decision-making. How can a judge adequately assess risk without knowing the full offender's capacity to harm? And I thank you for letting me tell my stories.
Thank you very much, Olive. Next, we'll hear from Tara.
Governor Baker, Lieutenant Governor Polito, and to everyone in this room that this concerns. Thank you for allowing me this opportunity to address all of you today regarding the importance of serious consideration of, and the ultimate passing of House Bill 4290, an act to protect victims of crime and the public. I met Kevin McCarthy on an online dating site in October 2015. I met him for the first time in person soon thereafter. I found out months later that he was involved with and abusing 2 other women while we were dating. When we started dating, KM had another woman living with him, whom he had told me was his children's nanny. I did not find out until over a year later when this woman filed an RO, left him, that she was in fact his live-in girlfriend and was being mentally, verbally, and physically abused by him. Around this time, this woman sought her RO. Kevin McCarthy was also actively abusing me. In one violent attack while I was driving, he punched me so hard, breaking the bone under my eye and forcing me to drive around for over an hour with my eye completely closed. While I was too afraid for my life and not yet ready to come forward at that time, charges were filed relating to the third woman, and there was a manhunt for him in July of 2016. Kevin McCarthy was eventually caught and sent to jail in August of 2016 after being on the run for over a month. He was sentenced to 90 days and was out in 60 days because of good time. He got out of jail on October 17, 2016, and 3 weeks later, he held me captive in his home and violently, physically abused me the entire weekend, telling me he would kill me, slapped me in the face, cutting it with a ring on his hand, bashed my head into a door repeatedly, and strangled me. I was hit so hard, I had 2 black eyes, my nose turned black, and my jaw was bruised. he had court 2 days later on November 9th, 2016, for the other case, and was put on a GPS bracelet and ordered to be in a batterers program, yet the abuse of me continued. At the end of December, Kevin held a knife to my throat, during which my legs became weak and I fell to the floor, all while he continued to jab at my head. I thought I was going to die. In March 2017, Kevin had a trial for the assault against the first woman and was sentenced to 90 days and was out again in 60. The abuse of me began anew a month later. Kevin McCarthy came to my job and raped me. I could not take any more of his abuse. I finally reached out to the DA's office as they were aware of his previous cases. I needed to make sure that if I was going to press charges, he would be held on dangerousness. This is because Kevin McCarthy made it clear that my restraining order was just a piece of paper and it would not make me safe, as it did not make the other two women safe. Kevin also reminded me that if I were to have him charged, I would be sorry, because he would either, number one, not be held, or number two, he would be out in 60 days and I would really get it. I truly believed he would kill me. This fear led me to take out a life insurance policy because I thought I was truly going to die at his hands. Kevin is a violent and dangerous person. He already had a lengthy, violent criminal record. He had proved over the course of over 2+ year relationship that dangerousness does not diminish with the pendency of a case. Dangerousness does not expire after a period of 90 days, nor will it imposition of conditions such as a GPS bracelet or batterers program. If prosecutors had the ability to revisit the issue of dangerousness while his previous cases with other victims were pending, it could have spared me and the other victim who was living with him the abuse we both endured at the hands of this evil, violent human being. I am so thankful that Kevin McCarthy was ultimately able to be held on dangerousness when he was picked up on the warrants for the charges filed for abusing me. I believe that his removal from society may have saved another victim from his violence and maybe even have saved a life or lives, including mine. Once he was behind bars, the victim that was previously living with him felt safe enough to come forward to speak in more detail about the violent physical abuse she suffered, and more charges were filed. Kevin was indicted on all of our charges, and our case was moved to Essex Superior Court. He was held for 4 years until our trial, and he accepted a plea deal and was sentenced to 8 years with time served. The time during which he was held on a 58A was such a relief that I did not live in the constant fear, and I was no longer suffering his violent abuse. With him being held in jail, we could finally breathe. Knowing he was behind bars, I was able to safely go forward with prosecuting him. I will forever be grateful to feel some type of freedom. House Bill 4290, an act to protect victims of crime and the public, would expand upon the tools available to prosecutors in the courts, is crucial for the safety of victims of violent and dangerous abusers such as Kevin. Violent repeat abusers need to be held to protect innocent people, the victims of these abusers, as well as potential future victims they may seek out, as Kevin repeatedly did. Our cases are a perfect example. Thank you.
Thank you, Tara, very much.
Thank you.
We'll now hear from Jennifer Lane, Community Voices, who will read Sophia P.'s statement.
Governor Baker, Lieutenant Governor Polito, and to all here today concerning this important legislation, House Bill 4290. Today, I am reading this statement on behalf of survivor Sophia. KM was involved with 3 different domestic abuse cases with 3 different women during the 4 to 5 years I was involved with him. At first, I was too scared to report all of the horrific abuse I suffered, as I feared it would put me at greater risk of harm. I gave the police enough information, and KM was charged with assault against me. He then went on the run from July 2016 to August 2016, and I was on edge every day. I lived my life in a bubble. I watched everything, people in cars, in stores, and in restaurants. I feared he would harm my family, as he always threatened that he would. KM was eventually arrested and placed on a GPS bracelet. He was ordered to attend a batterers program, which did not help the situation. I learned he was involved with the third female, who he also violently assaulted. When I found out about this new girlfriend, I knew I had to come forward with the whole truth regarding the extreme abuse I suffered at his hands. I knew at the time he would kill someone, and I couldn't have that on my conscience. Once KM was charged relating to this new victim, he was held on dangerousness. I finally felt safe enough to meet with Detective Benedetti to give a full statement regarding the extent of the abuse I suffered from KM. I was punched in the head, in the face repeatedly, once causing my front teeth to go through my lip, requiring plastic surgeon to fix it. I have a visible scar to this day. I've been spit at, stabbed in the back, had a knife put to my throat, slicing my throat, which has left another visible scar. My 2 front teeth were cracked from several slaps. He broke my pinky, hit me repeatedly with a golf club until it broke, the sharp edge of the club catching my hand and severely breaking the skin, again leaving a scar. KM used several objects to abuse me with whatever he could get his hands on: broom handles, hockey sticks, golf clubs, a wooden paddle, a leveling tool, cell phone, a bike pump. The list goes on. With pictures documenting my injuries along with the statement, the case moved to Superior Court. During the time he was held, I felt some freedom. I was able to breathe despite lots of anxiety. There are many nights to this day I have nightmares and flashbacks to what I endured through this man's hands. This will never change. Violent and dangerous abusers like KM do not stop being dangerous when they appear in court and cases are pending. Violent offenders like KM move on and find new victims, despite court orders and conditions such as GPS and batterers programs. Often information regarding the degree of danger an abuser poses to the victims and future victims might not be apparent or available at the abuser's first or even second appearance in court. Prosecutors and judges need options that will allow for victims to feel safe enough to come forward with hope that the system is able to respond and protect victims as well as the public. If prosecutors had options that this bill would provide for, they would have had a stronger case for dangerousness, particularly considering his entire criminal record. I truly believe that once he was able to be held on dangerousness, other potential victims were protected. It gave me safety net I needed to report all of the abuse I suffered. Thank you for consideration and support of House Bill 4290, an act to protect victims of crime and the public, a bill that will surely serve to protect future victims from dangerous, violent people such as KM.
Thank you, Jennifer.
Thank you.
Governor Baker?
Kind of hard to know where to go after listening to all of you. I do want to thank you for your courage and your willingness to share your stories. I'm amazed you got through them, to tell you the truth, because I just had to listen to them. I didn't have to deliver them. And I just want to focus on a couple of points that you all made. One of the first points you made was the inability of the judicial system to incorporate the full history of someone into the process around determining dangerousness is a fundamental flaw for you and for those like you, because you know what the history of these individuals is made up of, and you know how dangerous they really are. And because of that, it has a profound impact on your willingness or the willingness of others to even come forward in the first place. And anybody who thinks that survivors and victims don't talk to each other and that they aren't sharing information with one another about how difficult it is to press a case and to expect the courts to give you the same deference that they give to the person who's been beating or abusing you or your family member, has to have an impact on those who are willing to come forward in the first place. And your second comment's about the challenges of even seeing a case through when there are repeated violations of restraining orders and ankle bracelets and every other means and mechanism that doesn't work in many cases to protect you or your family members, is an incredible burden to put on the back of someone who's already suffered at the hands of their abuser in the first place. I can't understand, honestly, why this is such a hard concept for so many in public life to grasp. I completely agree with Aaron's comment that if you put this one before the people, the vote would be 90-10. And the 10% would probably be folks who didn't understand the question. And I can just tell you this, we'll do everything we can to try to get this done before the end of the session with the legislature. And your words and your commitment to this cause on behalf of yourselves, your family members, and your fellow survivors is honestly profoundly graceful and dignified and courageous, and I thank you for your presence.
I think someone said that it's the responsibility of government, number one, to keep the public safe. It's a general statement, but a very important statement. And that's just not in times of crisis, it's in times of everyday life. That shouldn't have to be said, but it needs to be repeated. What I feel, and I know the governor feels as well, is as a mother listening to you, it's our jobs to keep our children safe. And it's our job to support their health and their well-being, and most importantly, their happiness. And to hear your stories of children, 7, 8, you 11, not kept safe and robbed of their innocence, and to have to live a life, as you've stated now, coming here today, with this in them and part of them, is unacceptable. Knowing that these gaping holes exist in our laws, that we can fix them, and we can give victims and survivors a level playing field and a chance for a safer and better life. We're asking for that chance to have an assessment, to have the court weigh in the past as well as the present in evaluating someone's dangerousness. If someone is dangerousness, it doesn't just go danger by demonstration of their past history and the demonstration of the act before the court that never goes away. A restraining order doesn't make that dangerousness go away. A GPS tracking device doesn't make that dangerousness go away. It might work for normal people, having a boundary, but if someone is dangerous, it's not going to work. And that false sense of security that the justice system relies on in making decisions doesn't work. So we need to fix it, and we need our friends and colleagues in the legislature, friends here that understand this, to elevate your voices and to provide, again, that level playing field, to give DAs like DA Blodgett, DA Quinn, DA Cruz, DA Early, DA Gallooni, all who have hosted and been part of the advocacy for these changes to be made, the tools to protect you and to encourage victims and people living in harm's way to come forward. And I also want to thank the many provider groups, the survivor groups, Community Voices, MOVA, and other groups all throughout our Commonwealth that work with survivors and elevate your voices every single day, and for working with our administration to bring this more to the forefront. And it is our hope, while in office and in these positions, that we can accomplish this for you and for others and for the future safety of children and for people in our Commonwealth.
John, do you want to say anything?
No, I said when I opened up, this is, my opinion, the most important legislative fix that I've asked for and seen in 20 years as district attorney. I'm blessed. I have an incredible staff. My first assistant, Muriel Stirls, up back, my deputy first assistant, Kim Fatella, my victim witness director, Maureen Leal, and the deputy director, Michelle DeFeo, spent countless hours on each individual case doing the best we can to fashion some justice. And we need the tools. We need new tools. We need more focused tools. I've been criticized in many quarters because I filed more 58As than any other DA in the state. What is not said is that over 90% of our 58A petitions, a judge, after a hearing, does find dangerousness. So I stick my chin out on that and say, go ahead. To me, it's a badge of honor for my office, but it's just not enough. And I brought this up in my board meetings. I'm a member of MOVA. I've been in MOVA for over 15 years. And it does bother me greatly that the most important thing we do as DAs is to be a voice for victims, and we need to do more. So I thank you, Governor Baker, and you, Lieutenant Governor Polito. And I look to my legislative delegation and ask, please dig in. Please dig in and help us. Thank you all for being here.
Move on to the press conference portion. Governor Elgin can stand up here.
You guys come on over here. John, just I don't really think there's a lot we can add from the podium. I think the people who came here to tell their stories pretty much said it all, so I'm just going to open it up to questions. Well, I guess the first thing I would say is that the folks who've come forward at all of these, while their stories are incredibly individual and personal to them, there are several themes that come through in all of them that speak to why this legislation is so necessary. I mean, time and time again, we hear stories from people about the history of the person who has violated or abused them or a family member, and the fact that that history can't be incorporated under current law into making a decision on the dangerousness of a particular individual. And for the victims, you know, several of the folks here today spoke to this and spoke to it eloquently. They said, look, just common sense would tell you that if somebody repeatedly engages in these kinds of activities, that should be factored into whether or not they should be considered dangerous when you make a decision about whether to let them out. The second thing was this incredible fear about retribution. There are many of these cases that involve people who don't know each other, but significant numbers of them involve people who do. And the concern that so many of these folks have about coming forward, about basically putting themselves, if this person doesn't end up being held until trial, at personal risk, and having that personal risk they put themselves in ultimately determined to be a legitimate concern, you have to believe that that message spreads across the victim and survivor community and makes it very challenging for people to even consider coming forward. And the third theme, which once again played out here, was this whole issue about the fact that violence and assaults on children are not even categorically allowed to be part of the conversation about determining dangerousness, even though there's a ton of literature out there that makes very clear that people who have violated one child have probably violated many. And to not incorporate that into the larger conversation about determining dangerousness puts the parents and the children that are involved in some of these horrific crimes in a terrible position when they're trying to make a decision about whether or not to do something. I thought the comments that were made earlier about the pride that one of the moms had about their son's willingness to come forward and the number of people who he may have saved by virtue of his decision to do that, and the fear that they had about what might happen if he did come forward, given the loopholes that exist within our existing laws and the fact that everybody in the survivor and victim community know this, is a really powerful statement about the burden we put on folks who make this decision. And I've heard this over and over and over again in every event I've been at. And I don't understand why this seems to be such a tough concept to get across and to fix. This is not the overturning of our criminal justice system. It is on behalf of victims, closing certain loopholes that make them feel time and time again like the deck is stacked against them and stacked for the people who are taking advantage of both the law and of them.
Why is this?
I think the main reason the Lieutenant Governor and I have made such a case on this one is these stories bother us. These stories stay with us. These people who come forward and tell these stories, they ring in my ears all the time. And they are constantly reminding me that for 7 years, we've been trying to close these loopholes and have failed them and so many others. And this is a relatively uncomplicated fix. And it would give DAs and the courts a relatively simple set of tools that they can incorporate into what most people would consider to be common sense decision-making when they make decisions about dangerous. All we're looking for here is a hearing and some changes to who you can have a hearing on behalf of and the ability to incorporate history into those decisions, both either prior to the arraignment or after. I mean, keep in mind that a number of the people who've talked to us in these cases have been people who have come forward at great personal risk, tremendous fear in their heart, to make their claim. The person ends up in front of the judge decides based on the evidence that's available at the time to let them go with a GPS device or a restraining order. We've had people talk about the fact that they have then had their abuser cut their GPS device, ignore their restraining order, and abuse them again and again and again, and the court can't take that information into consideration to make a decision about dangerousness, before or after somebody comes forward. Honestly, most normal people would say, this makes no sense. And they'd say that because they'd be right. And I sit here and I look at this and I think about this great state that we have had the opportunity to govern through a terrible pandemic and all sorts of other things over the past 7 years. And I believe in this state. I believe in the people. I believe in the process. And I believe people in public life here want to do the right thing. And I struggle with why this is such a hard sell. I don't really know what the other side of this equation is. What I will say is the Lieutenant Governor and I have supported just about every single piece of legislation that's worked its way through the process and onto our desk to do something about the issues associated with the over-incarceration of individuals. I mean, I think the DOC is down 45, 46% in its inmate population since we took office. We've signed major reform bills. We've worked on major reform bills because we believe there was work that was needed to be done there. But the idea that somehow just because you've done all this, you can't possibly deal with this other issue over here that's causing real harm to kids and families and victims and survivors. I mean, we should be smart enough to be able to figure that out and to treat all these issues on their own terms.
There are many civil liberties, ACLU and group, also Jane Doe, and they said that it's
Well, first of all, Jane Doe does support a number of elements of this legislation. Secondly, many of the member organizations of Jane Doe support the entire legislation. And thirdly, when we did the event in Springfield, most of the people who spoke at that event were people of color, and they were women. And the one that I will never forget was the woman who came forward, told her story to law enforcement and to the courts. It involved an individual who practically killed her. They didn't even get a dangerousness hearing on him. And she walked through all of the things that she did while he was out and she was waiting for his case to go to trial to protect herself. Her entire life was dedicated to trying to put herself in a position where she would be safe. And just in case, when she went to work, a place he knew she worked, she made it a policy to park in the parking lot in the place where she knew the surveillance cameras would see her arriving to work and leaving to work, so that if he came and kidnapped her, which was her greatest fear, there would be a video that would show that it occurred. So I don't think this is about race. I think this is about fairness. And I think this is about doing the right thing on behalf of people who trust in the system at great personal risk to come forward and to make their case.
And explain your views on when people are concerned about
Well, first of all we're looking for here is a hearing. That's point number one. Point number two, in addition to a hearing, we're asking for the full body of work of the individual who's been accused to be incorporated into that decision-making. Now, if you've been convicted of a series of crimes, violent crimes, I can't imagine why anyone, white or black, wouldn't think you should incorporate that into making a decision about what to do with regard to dangerousness. I don't happen to think the things we're talking about here are a massive step back from the legislation and the work that we have supported as an administration for the past 7 years. But I do believe there are important elements in ensuring that anyone who has the guts and the courage to come forward and to make their case about the abuse of themselves or a family member will believe that the court system will treat their concerns seriously and incorporate the full body of evidence that's available to them when they make a decision. I don't want us to go back to the way it was. We wouldn't have worked so hard on the legislation that we filed to get it passed if I did. But in this particular case, across the Commonwealth, these are just the people who come forward who are talking to us. There are thousands of other people who are afraid, with good reason, and many whom believe the court system is not on their side. And they are just as important as anyone else, and many of them are people of color.
to respond to, one of the
Come to one of our hearings. Come to one of our roundtables and see if there isn't data. And part of the reason there isn't data is because a lot of the people who are most profoundly negatively affected by this are afraid to come forward in the first place. And I believe that if you ask the DAs that question, the DAs, just like John Blodgett did today, could give you lots of examples of why this matters. That Plymouth event, Karyn, that Plymouth event, almost everybody who spoke at that Plymouth event, their stories were about the continued abuse that they were subjected to after they came forward. Ankle bracelets being cut, restraining orders being ignored, and physical violence brought down on them over and over and over again. I don't know how much more data. I mean, that was real life playing out right in front of us.
And can you just also
Yeah, I should let you talk to that.
just to respond directly to
You want to speak to that one?
It's very simple, Karyn, very simple. The fact that force is necessary and to me, it's really mind-boggling. Are you going to tell me that a situation in which an adult male grooms his victims over a period of time, and there's such an age difference, that's not force? I read an example this morning of somebody who was 45 who groomed his victim online deceitfully and met up with the 15-year-old girl and had intercourse with that child. And do you need a knife or a gun to someone's head? The force is the age difference. So, I mean, this, again, as the governor said, is totally common sense. And we work hard every day to protect victims in that regard. So it's, to me, that ruling, and the SJC has said repeatedly that the legislature has to fix this, that they need a legislative fix. And that's why we're here today. And that's why Representative Tucker and Representative Polito, I'm sure they're supportive of this. But this is what we need. It's just, as the governor said, and Lieutenant Governor said, it's common sense. We're here to protect the public and protect children. We just need the tools.